Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract issues. Today, I'm going to talk about whether an employee can refuse to sign a non-compete. So, if you're a professional, it's very likely the employer is going to make you sign some kind of employment agreement or perhaps an independent contractor agreement. And most of the times, a non-compete will be included in the employment agreement. So a non-compete is a restrictive covenant. And a restrictive covenant essentially stops the employee from doing something either during or after the employment relationship has been terminated. So if a professional has been presented an employment agreement and it contains a non-compete, the potential employee can certainly say, I'm not going to sign the non-compete if you want me to be a part of this company. And then the company can say back to you, unless you sign the non-compete, we're not going to offer you the position. So it's a matter of negotiation and leverage. Most employers are not going to just say, fine, you don't have to sign a non-compete unless the employee is going to give something up. It is absolutely standard in the healthcare profession, in sales, in other industries to have non-competes. It's just a standard part of being a professional. So the fact that your employer is asking you to sign an employment agreement that contains a non-compete, they're not out to get you. It's just kind of a normal part of doing business. Now, whether that non-compete is reasonable or not, or even enforceable or not, is kind of another question. There are a few states where non-competes are completely unenforceable. So first, you need to check and see if your state is one of those. And then next, any state is going to kind of take a reasonableness standard in determining whether a non-compete is enforceable or not. So they're going to say, all right, what is the scope? Meaning, what is the non-compete stopping you from doing? And then how long does it last? And then what is the geographic restriction? Like how far? What is the territory that you cannot continue on doing what you were doing for that employer? There will be a point for many of the people that I assist with kind of contract review where they say, look, because of the situation that they're in, meaning they're in a city that they grew up in, that they have family in, their kids go to school there, and there's no scenario where they would be able to move away from the city, the non-compete can be an absolute deal breaker. And there are others who are moving to the city specifically for the job. They have no ties to the city and they could care less if they have to move away after the contract ends. And so in the first scenario where the non-compete is extremely important, as I said before, it can be a complete deal breaker. They can say, look, I'm not signing a contract with a non-compete, and most of the time the employer will just say, well, then we're going to find somebody else. Whereas it could be someone who could care less about the non-compete, and then it's not even an issue at all. So can the employer force the employee to sign a non-compete? Absolutely. They can make it a part of the employment contract, and obviously the employee is going to have to sign the employment contract before they start, but it certainly is up to the employee whether to sign it or not. Now, if you've signed the non-compete, then you need to be willing to live up to and deal with the terms of that non-compete. I mean, obviously, many times I get calls from people who have signed an employment agreement that contains a non-compete, and then after the contract terminates, they say, oh my God, this is such a terrible non-compete. How do I get out of it? Well, it's very difficult. Only if it's in a state where they're completely unenforceable, obviously, that's pretty easy. We can work out some kind of deal with the employer, meaning, and almost always it's an amount of money that the employee has to pay to get out of the non-compete. Or if it's considered unreasonable in some respects, meaning, as I said before, it's too long, it restricts too large of a territory. The scope of it is, like let's say you're in software sales and then the non-compete says you can't do sales at all anywhere in any industry for a period of time. Well, that probably would not be enforceable. It should be specific to what you're doing for the employer. And let's take a physician, for example. Maybe you're in internal medicine and you could be a hospitalist. You could be doing urgent care. You could be doing ER. You could be doing primary care. Well, if you're a hospitalist for an employer, then you should be able to do those other things and not just stopping you from the practice of medicine. So you really want to make sure it's specific to the scope that you're doing for that specific employer. Well, that is a little breakdown of kind of whether an employee has to sign the non-compete or what are some kind of ways to get around it. If you have any questions about your employment agreement, independent contractor agreement, non-compete clause, feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, ChelleLaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. All right, appreciate it. Thanks.